InSight Byte. Welcome back, everyone. InSight Byte number 3, public law. What is it good for? Continuing our look at the executives of Australia outsourcing now offshore detention of non-visa holding arrivals, predominantly via boat. So since 2001, strong policy of offshore detention, including other sovereign nations such as Papua New Guinea and Nauru, and also via third-party or independent contractors. So signing memorandums of understanding, MOUs, with other sovereign nations to allow the Commonwealth of Australia to operate offshore detention facilities on that other land, and staffed, managed, executed by private corporations. So the big contract with Transfield and then subcontractor Wilson Security at this time has seen that power, or the exercise of executive function, the function of government executing the law, been operated via third parties, private companies. And there's huge issues around that, isn't there? There's huge issues around that, because we're then now delegating power down to individual corporations who are not bound by the rules of government, do not have the same public scrutiny. For example, the public service values, which are entrenched in that work around accountability, transparency, moral, ethical codes, all that is gone once you engage the private sector. They may have their own values and mission statement and corporate blah blah on the website, but it's very flexible and totally driven by profit for shareholders. That's the whole raison d'etre of a corporation, is to make money. That's what it's there for. It's not about public service. So as we talked about in this subject course a lot, the minute you're outside of the three arms of government, that scrutiny of the exercise of power is really diluted. And you can see here the government seeking to operate at arm's length through private corporations. As exemplified by the case of Plaintiff M68/2015 and the Minister for Immigration and Border Protection in 2016. So interesting analysis and different judicial approaches here, because we're outsourcing public functions, and we know deprivation of liberty is a serious matter and in exclusive domain of the courts. So Nauru had agreed that people arriving via boat to Australia could be deported, any unauthorised maritime arrivals, and they would process their claims for asylum in and on Nauru. It was agreed Australia would engage contractors. So there was a contract with Transfield to provide the services. The plaintiff was Bangladeshi, who entered Australia's migration zone via boat seeking asylum in 2014. So unauthorised maritime arrival, section 198 of the Migration Act. An officer must take an unauthorised maritime arrival from Australia to a regional processing country. So authorised by legislation, in fact, must was the word used. And when we get to statutory interpretation, we'll understand that is an order. That's not discretionary, that's the officer must. So the plaintiff then gets detained in the regional processing centre on Nauru for about 5 months. Allowed to travel to Australia for medical treatment, however, lodged an application to the High Court before it was back in Nauru. Argued it was contrary to Chapter 3 of the Constitution, i.e. the executive detaining beyond their power and not by the courts. So could the Australian government be said to be doing the one detaining? Or is it because they have general control over that centre in Nauru that they're still? Or is it an arm's length arrangement? Well, the majority of judges found that the plaintiff was no longer detained by the Australian executive. And once you hand over to Nauru, then you're no longer detained by the executive. So French Kiefel and Nettle saying, well, by taking her to Nauru, ceased upon her being handed over, the Commonwealth's power to detain for the purposes of removing her from Australia ceased upon her being handed over to the government of Nauru. Interestingly pointed out that once she was on Nauru, she was in breach of their Immigration Act. I mean, that's a bit harsh, isn't it? If you've delivered someone somewhere. But anyway, as she's arrived there, their Immigration Act requires a person who's not a citizen must have a valid visa. And even if they were taken without the consent, the Immigration Act applied to her. So she was obliged by breaking their immigration rules to remain at the centre under supervision and not free to leave it because of the residency requirements of the Nauru government. I mean, that's a bit rich of an argument, isn't it, with respect? And also carrying on in the judgment, it's very much to the point that the restrictions applied to the plaintiff are to be regarded as the independent exercise of sovereign legislative and executive power by Nauru. The recognition that it was Nauru that detained the plaintiff is important. So a very interesting judgment. It's very much to the point that the Commonwealth could not compel or authorise Nauru to make or enforce laws. So the argument goes, once that she was on Nauru and it was Nauru that detained the plaintiff, the Commonwealth could not compel or authorise Nauru to do anything further with the individual. Therefore, the Commonwealth did not itself detain the plaintiff. What do you think about that judgment? Now, Justice Bell and Gaglier disagreed with the plurality and felt that the detention was caused by the executive. Bell says caused and effectively controlled by the Commonwealth parties. So that's that nailed down. And Gaglier says if the plaintiff had attempted to leave the regional processing centre without permission and Wilson security staff had been unable to persuade her not to do so, the staff would have sought to gain the assistance of the Nauru police force to deal with the unauthorised departure. And again, the Wilson security staff act as authorised officers capable of engage in measures designed to prevent her leaving. They're all within the scope of the services which the Commonwealth had subcontracted Wilson to perform. These were to be provided not only in compliance with Nauruan law, but also in compliance with the Commonwealth policies as notified to Transfield from time to time. The conclusion is to be drawn is that Wilson security staff exercised physical control over the plaintiff so as to confine her to the regional processing centre. So the argument here is no, the Commonwealth paid Transfield, who's paid Wilson, subcontractor, to restrain and detain the individual. So of course Commonwealth is detaining them. The procurement of so they acted in the relevant sense as de facto agents of the executive government, the Commonwealth, in physically detaining the plaintiff in custody. What do you think of that judgment? Her Honour Justice Gordon took a different view and felt that because the Commonwealth facilitated, organised, caused, imposed, procured and resulted in the detention of the plaintiff at the regional processing centre. The plaintiff contended that the detention had been funded, authorised, caused, procured and effectively controlled by, as if at the will of the Commonwealth. The effect of this was that as a matter of substance, the Commonwealth detained the plaintiff. That contention should be accepted. The Commonwealth detained the plaintiff on Nauru. The Commonwealth, by its acts and conduct, detained the plaintiff outside Australia. So Gordon lists all the activities in the MOU and basically found that Nauru was an agent of the Commonwealth under that MOU executed by Transfield and Wilson Security. Now, so once you're in the detention net by the Australian Commonwealth and then you're placed in detention somewhere else, you're still in the Commonwealth net, aren't you? That was Justice Gordon's contention. So the second question was whether, assuming that the executive had detained the plaintiff, whether that was unconstitutional, the detention offshore. A majority of the 5 judges in Plaintiff M68, so French, Kiefel, Nettle, and together with Gagler and Keane, found that detention was not unconstitutional because, wait for it, drum roll, it was not punitive. That old chestnut. So by defining it as non-punitive, you've escaped from that exclusive power of the courts in the Venn diagram around detention and punishment and incarceration, and you're saying, oh, it's not punitive, it's administrative, and therefore the executive can do it. It was incidental to the performance of Nauru's offshore processing functions. Now, what's interesting is Gordon's dissent. Her Honour accepted legislative power with respect to aliens may include some power to detain a person for the purposes of facilitating their removal from Australia. Do you remember the aliens exemption in the Constitution, allowing executive to have control over that migration? Removal from Australia was complete when the plaintiff arrived in Nauru. So she's saying, put simply, the alien's power does not provide the power to detain after the removal is completed. That's a good argument, isn't it? Like, once you've removed your alien, that's it, isn't it? Who are you then to authorise lockup in someone else's sovereign state? So Justice Gordon held the Migration Act purported to authorise executive officers to detain a person who had not committed a crime, and that could be justified as an exercise of the alien's power. However, just as the executive could not detain a person without reason within Australia, it could not detain a person outside of Australia. And Gordon J. emphasised that the executive detention was an exception to the general rule, and that is, the power to detain is exclusively a judicial one. So, she goes on to say, as a matter of fundamental principle, it's essentially and exclusively judicial in character. Section 198 vests part of that function in the executive. That is not permitted. The plaintiff's removal from Australia by the Commonwealth was complete when she arrived on Nauru. The Commonwealth had no need to and had no right to detain the plaintiff in a foreign state. There you go. What do you think of Gordon's dissent? Does that stack up with you? All right. So, thanks everyone. That concludes InSight Bytes for this week. Next week, Human Rights and Public Law, week 7. Thanks. Look forward to working with you in class.